Good morning, Mr. Kiley.
I am Thomas Kiley, and I have the privilege of representing Gary Crossen. And I have represented Gary Crossen since August 28, 1997. I've been involved in this matter for its entire 10-year history. 10 years, Justice Cowan, is a very long time. It encompasses the entire time that Justice Ireland has been on the bench. It encompasses the entire period of time that the new model rules have been adopted in Massachusetts. I want to stress at the outset that with respect to the question of whether something could have been looked at in 1997, the answer from Mr. Crossen is yes. Mr. Crossen submitted written responses. They're before you as Exhibits 167 and 168. Exhibit 168 is a detailed, factual presentation and musters the law as it existed at the time.
I agree with you that 10 years is an awful long time, but couldn't counsel, you and others, at any time, if they felt your clients were being prejudiced by this delay, have filed a motion to dismiss before the board and then come to a single justice here and said, look, this thing has dragged on too long, they're persecuting us, et cetera, the publicity is killing us, Crossen lost his job at Foley Hogue?
There are a lot of things I could have done, Justice Graney. This petition wasn't filed, and for the first 5 years of the time period, there was no occasion for me to file any such motion. In the fall of 1997, the written response says, do not defer. We would like to deal with this matter now. There was never an invocation of privilege on the part of Mr. Crossen. Mr. Crossen fully participated with the Justice Department, participated in the no holds barred, no rules, no proffer, no protection interview because Mr. Crossen believed everything that he did here was right. Now, the situation for Mr. Crossen picks up after the involvement of Mr. Siegel's client. He learns of this event in Nova Scotia after the fact. He learns of it the weekend of June 8th of 1997. And what he learns on June 8th of 1997 is that Paul Walsh has told a lawyer and investigator that in advance of the trial, Judge Lopez told him, the clerk, who the good guys and bad guys were, who the winners and losers were going to be, and who the liars were. That is indeed at paragraph 175 of the hearing officer's report. The special hearing officer finds that Paul Walsh was not credible in denying that he had made those statements and finds explicitly that the statements were made. That's the situation into which Gary Crossen walks on June 6, 7, 8 of 1997.
And that information had been uncovered by who, the investigator?
Kiley.
It is provided to them
By
Arthur Demoulas, who is imparting the information from Mr. Curry and Mr. Reed. And Mr. Crossen is also told that there is information which is to the effect that Judge Lopez didn't write the opinion, that Paul Walsh wrote the opinion.
But he says early on that in and of itself doesn't mean much.
He says it very explicitly, Justice Botsford, and if you read nothing else in this case after the argument today, I would ask you to read the exchange at pages 93 to 95 of the supplemental appendix that Ms. Kaufman has provided, which deals with the first recorded conversation that Mr. Crossen and Mr. Walsh engage in when Mr. Walsh is stinging Mr. Crossen in August. And it's a critical discussion because much hangs on the special hearing officer's characterization of Gary's repeated requests for a candid conversation to be somehow illicit. And in that, at page 93, Mr. Walsh says, then what do you want from me, Gary? And Gary says, I want what I told you I wanted when we met. I want a candid conversation about what was said, the accuracy of what was said, and to the extent that you take the position it was inaccurate, why would you have said such things inaccurately?
So your position is he really was searching for the truth, and the hearing officer is just wrong in inferring from that conversation that there was...
That is my position, but this conversation is critical, Justice Spotsford, because it's unvarnished. It is the first discussion that we have on tape in terms of what it means. And I submit that that question, why would you have said this, goes to Justice Marshall's point in the prior argument about puffing. And that is made explicit in the continuation of the quote. Mr. Crossen says to Mr. Walsh that there are two things that are going on. One is whether he wrote the opinion 100%. And the other is that he told the investigators who the good guys were, who the bad guys were, who the winners and losers were going to be. And what Mr. Crossen says, and this is at page 94, as he's describing that, the judge told you in advance who the good guys were, who the bad guys were, who the winners would be, who the losers would be, who the liars were. I submit to any lawyer who has been through 84 days of trial, learning that that kind of statement has been made is going to send off alarm buttons.
But isn't it so that in that, you can break that up into three parts, I guess. I mean, in terms of who the good guys are and bad guys are, she had sat through a very long jury trial, right?
That did not include Mr. Crossen's client, Francis Kettenbach, and against whom, for whom Justice Lopez had found in the first trial,
Right.
but against whom she sua sponte reversed the matter subsequently. Yes, she could make a judgment based upon judicial review, but she couldn't make such a judgment about Francis Kettenbach. Now, what Mr. Crossen continues and says is, I can fully understand how somebody in the selling of a job interview, in that context, would claim to have written something 100% when they had maybe only written it 87 or 85 or maybe even 50%. I can understand why somebody in a job interview might puff on the details. And I have no problem with the fact that you wrote the opinion. That's human nature to puff in that sense.
Mr. Kiley, why could not the special hearing officer have taken a different slant on that conversation? Instead of it being a search for the truth, it was a turning of the screw. Why couldn't she have found that?
She could. She
but-
did.
Well, except what she says, and it seemed to me quite interesting, was, this is the hearing officer speaking, I agree that Walsh, through his puffing, so she says he's puffing, and she found he was, unwittingly gave them, meaning the attorney, well, including your client, and their clients, a factual basis for their beliefs about the authorship of the decision and Judge Lopez's predisposition. So in an essence, she's saying, yes, at that point, they had a factual basis to believe that the judge did not author the decision and had a biased predisposition. And then she concludes, I have found that they ignored legitimate channels through which Walsh's allegations could have been fully investigated. So it seems to me that, at least from the hearing officer's point of view, what this boils down to is when an attorney is confronted with a factual basis for belief of bias in a judge, not hypothetical, a factual basis, is the attorney required to go only in one direction to investigate, or may the attorney engage in another method of investigation, which I think it is clear is not illegal.
I think, Chief Justice Marshall.
I don't know
that
the
is-
answer to that.
Well, you have put your finger, I think, on the nub of the special hearing officer's decision. And at page 200 of that opinion, she says, I'm not unmindful of the situation that Crossen and Donahue faced. She says that with this legitimate basis, that I say includes inquiring why somebody would make such a statement in a job interview, that's not puffery. And that's what Gary says on page 95 when he's just asked the straight question, what do you want from me? He wants an explanation why somebody would say something that is inaccurate, if it's inaccurate. Now, when I made my submission, that's Exhibit 167 or 8, and I don't know which it is, and collected the law, I collected the law that included cases that say, and Moffett versus Gilmore is the one that answers the question, and it's in our brief. What should a lawyer do when he's confronted with evidence of bias of a judge? And the answer is conduct an investigation. And the answer is who conducts it? And Moffett versus Gilmore says the lawyer conducts it. Don't turn it over to the court.
But the question is how it's conducted, exactly what is.
That ends up being the question, certainly, and why we end up here following the special hearing officer and the board decision. And the idea is we weren't allowed to tape. We weren't allowed to continue the ruse. But the point that I want to emphasize to you is 10 years after the fact, with the benefit of hindsight and the legal developments that have occurred, we're thinking of disbarring Gary Crossen.
What are the legal developments that have occurred that have changed the landscape between 1996-7? I mean, I know we've adopted,
among other things, the law with respect to surreptitious recording has developed. The ABA formal opinion that would have provided a basis to suggest that surreptitious recording is invalid as a matter of the model rules has been withdrawn. The question of whether a
well, that doesn't. I saw that, but it struck me at the time that I saw that didn't exactly help your client. Correct?
Well, I of course thought it did,
Okay.
Chief Justice Marshall.
Well, if you're telling me that in fact in 1996-97 the law was unclear, and then the law became clear against surreptitious recording, and then thereafter the law was clarified to not to permit, but not to find it an ethical violation.
Let me go at it differently. Let me
Sure.
take the example that you used in the drawing answers out of Ms. Kaufman and Mr. Siegel, and it's the testers area. In 1997, in June, when Mr. Crossen was deciding whether to continue the ruse, go to the Judicial Conduct Commission, go to the Chief Justice of the Superior Court, as the special hearing officer suggests. What we're really asking is that the lawyer in real time draw distinctions about whether it's okay in a testing situation for housing, whether it's okay to deceive in a situation where it's patent infringement. And what we're doing now is applying the judgment that there's a distinction between them and this case. Why? Because it involves judicial corruption at its worst perception. To me, that makes no sense that we would be doing
But
that.
isn't the point of the special hearing officer is that testing is one thing, but if you accept her findings, that there's the threats and intimidation and all the things that go on with the deception that put it over the rail, if you will.
And let's address that very directly. My client was not charged under the threats rule. There was an explicit threats rule. He was not charged with it.
Did the judge or did the special hearing officer make a finding that conversation on Special Appendix 93 to 95 was a turning of the screw, or words
No, I
to that
think
effect?
she finds that the later discussions of the turning of the screw.
Is there a
that later on-
distinction in the testing situations, that the testing questions and what happens generally happen in public. You go in, you order a Coke, and you get a Pepsi, or you go in and you ask if a house is for sale, and they tell you no, but the prior person was told yes. This is all in public, whereas this was all done very secretly. Is that a distinction that is?
It's a distinction, Justice Cowan. Whether it makes a difference, I don't know. Again, the point that I want to leave you with is on June 9th of 1997, this court adopted the preamble to the current rules. And it recognizes that lawyers have to make real-time decisions based upon incomplete facts.
Mr. Kiley, I confess I haven't read the transcript of the hearings. I've read the special hearing officers, and I've read the boards. And one of the things that I wondered about was how much Mr. Crossen, your client, had in fact explored the ramifications. I know about his leading of the Miano case, and I believe I'm correct in saying that after the New York meeting, I think he asked an associate at Foley Hoag to research the question very carefully.
I think, Madam Chief Justice, he indisputably did the following things. He asked for a check to be made with a Google kind of check. I don't know what we would have called it then, 10 years ago. But he asked for a background check on Mr. Curry to check out the source.
He asked a background check on Mr. Curry?
Correct.
Just from the Internet, though, right? Just an Internet.
I don't even know whether the Internet existed then. He asked for a background check. He interviewed he talked with Mr. Curry and Mr. Labonte to find out what had occurred. He looked at draft affidavits.
That comes through. That he clearly wanted to find out whether the information that his client had presented to him had any validity, and was it reliable in that sense. I'm turning to you're saying you have to look at the lawyer in real time. And this is this is a very serious range of decisions that are getting made, and to what extent, if any, do we look at what the lawyer did to make clear to himself that the course that he was proceeding on was in fact appropriate under our Code of Judicial Conduct.
What he didn't, I was running through what he did do. What he didn't do until after the fact was look at the question, direct the associate to look at the question about contact with a clerk and whether that would change the equation, the fact that Paul Walsh was an ex-clerk. That research was done after June 17th. There was research done on Mr. Crossen and Mr. Moffat, his associate, were themselves very knowledgeable about the wiretap law. They've argued cases here. They wrote a law review article. They were well aware of the wiretap.
Can I ask you a little bit about the contact with the clerk? We know that journalists contact clerks. Much is made that there was an internal memorandum as a general matter. That doesn't surprise me. Whether or not the internal procedures of a particular court, have their procedures up on the web, maybe they do, maybe they don't. But as a general matter now, I think most judges or courts ask their clerks to agree not to talk. But we also know, we have a new book recently out by a very reputable journalist called The Nine, and it is based on extensive interviews with clerks. So what, if anything, did Mr. Crossen conclude after he did the research?
The contact with the clerk was appropriate. That's what he communicated to others. A contact with an ex-clerk. You have the cases that the research was based on. The Elsie Hastings case has a notion of a qualified privilege. But we listed, again, in our submission the cases where contact...
Is there a difference in your mind between asking a clerk, what does the judge like to work for? What time does she arrive in the morning? How does she handle her caseload? How much does she give to her clerks to do? Does she like to draft her own opinions? Does she sit around and talk about the cases? as opposed to saying, what was the judge doing in this particular case?
There is, but there's a further distinction that goes to the notion of a qualified privilege and goes to the heart of this case. I think that the deposit that you have is different than the situation where you're asking about predisposition and bias and whether the judge has identified in advance of the trial who the winners and losers are going to be.
The problem, Mr. Kiley, as you can well imagine, is let's assume that there's something dishonest about a phony interview, not criminal, dishonest, and not all, but sometimes when parties lose, and particularly if they've questioned some of the rulings that a judge has made, they may feel that a judge was biased ab initio or became biased at some point during the trial and didn't keep an open mind until all of the evidence was in. Is a lawyer for a client then free to call up the law clerk and say, tell me what was happening in chambers? I have a sense that this judge was biased.
This court may end up answering that question differently and may have answered it slightly differently in Fidler and Soros for juror contact. And but what Gary Crossen did, he did not make such a call. He received the information consistent with what this court said lawyers should do in the context of juror contact. If you receive information that is a different situation, and in this case, Mr. Crossen received information that this special hearing officer said put him on notice, gave him a factual basis, a good faith basis to believe that there was a problem in this case.
So in the next case, I don't know, a lawyer says, the word around town is that, Marshall really has it in for whatever. Receives information. Or maybe the word around town is that Marshall really had it in for your client. Or had it in for,
Different situation. If the word were Marshall told Ms. Mellon who was going to win the case without having read it on the basis of who the lawyers would be, there'd be an issue. I say this when I come before you because you make the rules and you impose the disposition, and personally this is very important to you. I know it is. Clearly articulate the rules. If you do not want contact with judicial officials other than in the context of a case pending where there would be an ex parte notion,
Well, I
say
guess
it.
your point is,
Say
which
it.
we've gone over numerous times, that there were no such rules at the time that Mr. Crossen acted. It's certainly permissible to hire, in almost any case, a private investigator. They do it in defense cases all the time, to approach jurors and other kinds of things, to look into this kind of information. They did that, and it got to Mr. Curry, and then it got to your client.
Yeah, I do say there were no rules, but the reality is there were rules of broad general stroke,
Well,
some
there are
of
no
which we've had
flat-out
to
rule
afford. They don't deal, they're not,
Yeah, no
the
flat-out
ones we
rule
have
that
to
says
apply.
don't go near a clerk, a law clerk. No rule.
when we appeared before you as a single justice and the question was one of privilege, that's long gone. There is no privilege. There's no brief file on it, there's no privilege.
Okay.
Thank you, Mr. Kiley.
Thank you.
Ms. Kaufman?
Oh, can I have one procedural matter? I messed up on my appendix. There's a page missing.
Send it in.
Ms.
Send it
Mellon,
in.
Ms. Mellon has additional pages
As long
for
as
you.
Ms. Kaufman has it, we're
Oh,
welcome.
yes.
Ms. Kaufman?
Thank you, Your Honors. I'd like to start with answer to one of the questions that was asked of Mr. Kiley, which is how much investigation or research did Mr. Crossen do before he launched into his own plan for New York? And the answer is he really did nothing. He did the internet search on Mr. Curry. He never spoke to Mr. Lamonti. He never spoke to Mr. Labonte, even when they were flying to New York together. And that's the
Now,
findings.
Labonte's the investigator?
Mr. Labonte's the investigator who was in Nova
Why
Scotia.
can't someone rely on another attorney who's in good standing? The Internet would reveal he had worked in the Attorney General's office.
Actually, the internet didn't reveal anything. He didn't know anything about Mr. Curry. He had a feeling about him. That's why he wanted to check into him.
What did the Internet search that was talked about reveal?
Nothing.
Not even where he went to school?
Nothing.
No?
That's what the
Did
testimony
he
was.
talk with anybody else about Mr. Curry?
No, but had he would have learned that Mr. Curry had a very poor reputation. Because Mr. Adams, Mr. Sullivan, and Mr. Barshak were more than familiar with Mr. Curry and had a very, very low opinion of him. And Mr. Donahue did talk to Mr. Barshak, and Mr. Barshak told him, don't get involved with Mr. Curry. And that was well before anyone...
I'm sorry, who had talked to?
Mr. Donahue had
Right,
talked to
right,
Mr.
yes,
Barshak.
Yes,
and,
yeah.
and that was before anyone went to New York, and before these plans were made.
So
So he-
Crossen had no idea, no knowledge that Curry worked for the Attorney General?
That's
Had
correct.
graduated from, I think, Harvard Law School? Am I right? Or Boston College Law School?
I think it was Boston University. I don't remember. I don't think he
All right.
voted. I don't think he graduated from Harvard, but he may have, for all I know. I don't believe that's the case. No, he didn't know.
Mr.
From that
Ms.
internet
Kaufman-
search, he learned absolutely nothing.
Well, can you
Pretty
just
easy to
tell
get
me
an
when was
opinion of
the...
another lawyer in this town. I mean, to find out from other people what
It would have been
what
very
a
easy to get.
lawyer's
I'm
reputation
sure
is.
that actually his own investigator had contact with Mr. Reed, who was Mr. Curry's investigator, and told Mr. Crossen he didn't like Mr. Reed and did not consider Mr. Reed to be reliable.
Kaufman, help me out. When was there all the discussion about the Miano case?
The Miano case was discussed around the 11th of June.
That's before or after the New York meeting?
Before.
Okay,
And-
that's okay.
Yes. Mr. Shaw, who was friends with the Arthur T. DeMoulis, was asked if he would you let his office be used, and he said, no, there's a problem. And he gave Mr. Crossen the
Right,
site
right,
on Miano.
right.
And then that case was checked out of the library on June 12th after the decision was made to continue the taping in New York.
Yeah,
That
okay.
decision was made on June 11th, for sure, that they were going to go to New York and tape Mr. Crossen. And then on June 12th...
Hey, Mr. Walsh.
I'm sorry, you're right, tape Mr. Walsh. And then he read the Miano decision. And although he's abandoned it now that he's at this stage of the game, before the hearing officer, he claimed that he attempted, or that his goal was to conform his conduct to Miano. Miano said a lawyer could not be involved in such the taping to the extent that Mr. Crossen was. So that's the only case he ever read, the only research he ever did. After he got back from New York and went to Mr. Barshak's office with the tape, at Mr. Barshak's office, someone said, I think there's a problem with contacting a clerk. Have you done any research on that? And I might point out, too, before we even get to New York, a number of people asked Mr. Crossen if there were a problem with what he was doing, including his own investigator, Mr. Rush,
This is before,
before New York.
Okay.
And Rush said, is this legal and ethical? And Crossen answered, yes, I've had it checked and cleared by ethics, from which Mr. Rush concluded that he had gone to his firm's committee, which he had not. So it wasn't as if nobody suggested to him that there's a problem with what you're doing. And even Mr. Donahue testified that he asked Mr. Crossen whether he had checked into the legality and the ethics of it, and that Crossen said he would check into it and get back to him. Now, after he got back from New York and it was suggested to him that there was a problem with contacting the clerk, he did go to his associate, Mr. Zick, and he said, courts aren't going to like this. There's a case that talks about jurors, contacting jurors. He had in mind the Keprios case, the federal case that he actually had cited himself in connection with his federal court proceeding involving Mr. Kettenbach. He is the one who told Mr. Zick to look at that connection. He made the connection himself. And when he got back a number of cases recognizing at least a limited judicial privilege, he never informed any of the other lawyers about those holdings. All he said at the meeting in June with all of the other attorneys was, I've looked into it and there's no problem with contacting the clerk. Nothing about a limited judicial privilege, no information whatsoever.
Did anybody ask him afterwards? Because the Barshak meeting occurred before his associate.
Yes, did the research, yes.
Yeah.
After they got back from New York and after he did the research, he went to a meeting to discuss whether or not the Walsh information was going to be combined with the Charles Restaurant information. And he was asked at that meeting, he'd already had the research done, whether there was any problem with this contact with the clerk. And he answered, no, I've had it researched and there's no problem with contacting the clerk. Nothing about the holdings in those cases, every one of those cases, that there was a limited judicial privilege recognized. In fact, research has not uncovered any modern case that hasn't recognized a limited judicial privilege. The other interesting thing is, as was pointed out in the argument that Mr. Kiley just gave, is that if anything, the legal landscape was clearer.
Could I just ask you on the question of privilege? I mean, I understand the doctrine, and I've read the cases, and I understand that when there's a proceeding perhaps involving the judge or something, if I know that there's an attorney-client privilege, that there's an attorney-client relationship, correct? And I'm an attorney, I absolutely cannot, I mean, the law is, up and down cold, that you cannot try to penetrate that privilege by loose or non-loose, correct?
Right.
If there's another privilege, and part of that has to do with the fact that we don't want somebody who is representing the other party to get access to somebody who is represented party, whether or not they want to penetrate the privilege is beside the point. In other cases where there's a recognized privilege, statutory or otherwise, is it a violation of the Code of Ethics for a lawyer to attempt to penetrate that privilege?
Yes, actually, this court...
What's the closest case there?
I think if this court looks at its cases in dealing with those 4.2 issues, the employment cases, Messing,
yes, but
Clark,
you see, those are complicated because the structure there is, it's sort of partly even playing field. So in those cases, it doesn't matter whether the lawyer is trying to access privileged information.
But actually, this court doesn't.
No, I know it does that. But if you have somebody who's represented by counsel on the other side,
even people who are not, because those cases deal with whether or not the employees of the corporation are represented. That's what, and the question is whether they are or they aren't. Do you have to have the permission of the other side to talk to those employees? And those cases hold no. Only in certain instances can you say that those employees are represented. So really what you're dealing with is an unrepresented. What are the restrictions? Those cases address what are the restrictions on a lawyer's contacting someone who's not represented.
No, I understand that. I'm trying to find another privilege.
Okay.
In other words, because that is all infused with how, as it were, we conduct judicial proceedings with represented and non-represented counsels.
Well, in these cases...
But take another case.
For example,
take another case.
A doctor-patient privilege?
Yes, or a social worker privilege, and where it's clear that the lawyer is doing something that violates, and you have to penetrate that privilege.
Well, certainly, I can't give you a case I don't have a case in mind, but I know that Rule 4.4 now talks about you may not engage in conduct that violates the legal rights of another individual. Also, the broad language in those employment cases say generally that lawyers cannot invade confidential relationships and disguise their identity. In these judicial privilege cases, what the courts are saying is, and this court has always recognized that the deliberations of a judge cannot be intruded upon, except under extraordinary circumstances. And of course, we have the Fiddler and Solis cases, which say that you cannot talk to a juror. You cannot initiate communication with a juror, and if a juror initiates communications with you, the inquiry must take place under the supervision of a judge. So you wouldn't be allowed to fly the juror off to Halifax or New York and offer the juror a job in order to get the information.
Ms. Kaufman, the lawyer, did those provisions exist before the adoption of the new code?
Which provisions?
You can't interfere with confidential relationships, and you...
That Rule 4.4 was not in the code.
okay.
But our point in our...
No, I understand. I
Okay.
understand. I was really looking at a charging decision.
No, we didn't charge 4. Yeah, this is a code, and there was no specific provision that had that language in it.
Could the Judicial Conduct Commission have inquired of Mr. Walsh about any comments that may have been made to him in advance by the judge?
There have been inquiries, but even the Judicial Conduct Commission has to have good cause. I cite a case in my brief discussing the circumstances under which the JCC would be allowed to inquire of the clerk about deliberations. And of course, there was the Bonin case where Mr. Orfanello was allowed to be questioned about comments that Mr. Bonin had made concerning the fundraiser that he was going to attend. But that didn't involve his deliberations on a case. So that certainly is not, relevant here.
Well, except that it would be very unusual.
It would, yes, except to say that it would be very, very unusual.
I would suspect that if the Judicial Conduct Commission thought that that's what it wanted to inquire about, it would seek a court order.
I think so. But I would think it would come as a shock to the members of the bar that it would be okay. I mean, certainly now that the opportunity has presented itself, I would ask the court to make clear. But the idea that you could call up a clerk and ask about what the judge was, how the judge deliberated on the case and what comments the judge made as part of the deliberations, I don't think that the members of the bar thought in 1997 or since or before that was okay and a legitimate thing to do, a legitimate inquiry.
Thank you, Ms. Kaufman.
Thank you.